When you watch the conclusion of our feature on estate planning, some things are likely to catch you by surprise. Did you know, for example, that under the Inheritance Provision to Family Dependents Act, an ex-spouse can bring a claim against your estate? Attorney at law and well-known estate planning expert Denise Henry James points at what she views as anomalies under this act. She was addressing Maybear Investments Investor Briefing in March 2011.
I have some problems with the Inheritance Act because forget we started out by telling you you had testamentary freedom, right? Which meant in your will you will leave your assets to whoever you want. If you want to disinherit your spouse, you can. If you wanted to not provide for your children, you could have done that. It does not sit morally right with us that you can do such a thing. So we have embraced the Inheritance Provision for Family and Dependents Act, which is really saying, even if you are not in the will, or guess what? If you died without a will, suppose you fell down too low in the order, or you weren't even in the order, you can always bring a claim against an estate if you are a dependent and you are being maintained by the person before you died.
Mrs. James gives some ideas of beneficiaries and provisions.
I want to just spend some time on who these beneficiaries are. They started back out to the first category, which was what? Spouse. So that came back. Now we recognized what again? Legally married unions. We recognized common law unions. But we did the same restriction. You had to have been a single man with a single woman living together for 5 years. They added this category. Your former spouse. So you remember Georgia that even said you had a case where you had a will, where they've left the will because they didn't review it. If you have a former spouse who never remarried, then under this legislation, if you are providing for your former spouse, and think of it, a lot of us will be, because what are we paying? The mortgage for them, we may be paying the grocery bill, we may be paying rent for them. Once there's a financial provision, what's going to happen? They can bring a claim under this legislation for that provision to continue, even though you have died, you moved on with your life, you remarried, they are still just your former spouse.
According to the estate planning expert, believe it or not, there are circumstances under which a former spouse has rights.
But here's the trick, you notice what I kept emphasizing, as long as you never remarried. So what the gentleman need to do is what? Encourage the former spouses to get married, because once you've remarried, then you've lost the benefit under the legislation. But really and truly, what the court looks at is not just the fact that you're the former spouse, because they will look at what? Odds are you may be paying alimony, there is some benefit that is being paid, and the court will take that into consideration in determining what you're to get. After spouse now, they went to children, which is still good, because that's who you wanted to provide for. But this category, everybody, they have so opened it up. You have to realize that every permutation is covered. Your blood children are going to be covered. Children of the marriage, children of the union. So we're bringing in what now? Stepchildren, adopted children. And they're going on. Child, in your mind, you tend to think of what? Under 18, eh? It means anybody under 18, but anybody who is over 18 and up to 23, because you know what we're focusing on? Higher education. So if you're paying your children's university fees before you died and your estate is being done, then they can bring a claim that what? The university fees continue to be paid. Again, they didn't stop there. If you have any child, irrespective of the age, but they have a medical condition, so they may have a heart condition or handicapped in any way, then what will happen? They can bring a claim as well, because you would have been providing for them. And they're not finished. One more. An unborn child. So if you have left your spouse or your girlfriend or your common law spouse and she's pregnant and you've died, what can we wait? The minute the child is born, a claim will then be brought on behalf of the unborn child who is now born, that you make provision for them. So you have to bear all of this in mind.
What about parents?
And finally, they cover your parents, because it was the same top three that we had under the Intestates Act. So your spouse, your children, and your parents. But all of these persons, everybody, can bring a claim. So that you have to be aware of it, that even if you have your testamentary freedom and you've set out in your will what you want to do, make sure that you're aware that if you're making this financial provision while you're alive, expect them to bring the claim against your estate.
Quite an eye-opener. We trust that you learned something from our two-part feature on estate planning.